Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina and today's topic is When is Doing Good Bad? Understanding the Antitrust Implications of ESG. In 2019, Our Curious Amalgam explored the ways in which social responsibility agreements can run afoul of the antitrust laws. In particular, efforts by automobile OEMs that had agreed with California to comply with stricter tailpipe emissions in federal levels. Episode 16, check it out. Environmental social governance, or ESG efforts, have become even more mainstream in the last 3 years. In this episode of Our Curious Amalgam, we'll further explore what ESG is and why it matters to antitrust enforcement today. Joining me today is my co-host, Melissa Maxman. Hey, Melissa.
Hey, Christina. How are you doing?
I'm well, thank you. So you know a lot about this topic, having been our guest actually in 2019. So tell us a little bit about what we're talking about today and why it's relevant for the discussion.
So that's great. Yes, I feel like I was a little bit prescient in November of 2019. ESG, I had never heard that phrase before. It obviously stands for environmental, social, and governance priorities to maximize shareholder value in corporations. And this is something that is new to the dialogue in the last couple years. So while we sort of had an idea by the tail, today is the day to really explore what this means, what the implications are with respect to antitrust, and in particular the Noerr-Pennington doctrine. And I'm very pleased to have two of my favorite colleagues from the Exemptions and Immunities Committee of the Antitrust section. First is David Shaw. David is a partner at Morrison Foerster and has a lot of antitrust experience in mergers and litigations and counseling. But most recently, he was the Deputy Chief of Staff and Counsel to the Assistant Attorney General at the DOJ, where he advised and assisted the head of the Antitrust Division on law and policy related to the division. So welcome, David.
Thank you. Glad to be here.
And we have we decided to bring another guest for a cameo appearance. Derek Jackson is an associate here with me at our firm, Cohen Gresser in Washington, D.C. And Derek, whereas David is more of a experienced expert on ESG, Derek has been helping him out with some research and had some excellent ideas. And so we're going to be involving him in the discussion as well. Welcome, Derek.
Thanks, Melissa. Very happy to be included. So,
David, let's start with you. I gave a very shallow, superficial explanation of what is ESG. Can you explain to our listeners what we're talking about?
Sure. So as you mentioned, ESG stands for environmental, social, and governance. And it's really a movement to encourage organizations, I'd say especially businesses and their investors, to consider environmental, social, and governance factors in their operations in ways that might go beyond traditional, at least short-term shareholder value maximization. But a key argument to ESG is that paying attention to these factors helps to create long-term as opposed to short-term value. And I think ESG is really closely related to the idea of stakeholder capitalism and all the debates that entails. And in particular, ESG has become very prominent in the past several years. I mean, it's been around for a while, but the past several years has been a real sort of acceleration of attention to ESG, especially from large institutional investors and asset managers who've made it clear that they're paying close attention to ESG factors and making investment decisions. And probably not coincidentally, just about every significant company is also paying attention to ESG and talking about it.
So why and when does it implicate antitrust?
Well, Great question. And let me just be clear that there are many aspects of ESG that don't implicate antitrust at all. In fact, I'd venture to say that most ESG-related activities don't raise antitrust issues. But antitrust does come into play when we have companies, especially competitors, making agreements. And one aspect of ESG is attempts to make industry-wide or sector-wide changes in business practices. And of course, one company unilaterally making a decision to change a business practice in a way that might be more environmentally friendly or more socially conscious might not have a big impact depending on the company, depending on the sector. And of course, if companies agree together to make those changes in concert, there's a chance to make a much larger impact. But anytime you have companies making agreements like that, it's going to raise antitrust issues, and you're going to have to pay attention to those antitrust issues.
And is that simply because there's an agreement among competitors? I mean, aren't there some limits to that? So there are, and I think we'll have a chance to get into it. There are, of course, all sorts of opportunities to make pro-competitive agreements and collaborations, but the Sherman Act prohibits unreasonable restraints of trade. Certainly, it would be possible for for an agreement related to ESG activities to implicate that prohibition on unreasonable restraints of trade. Well, I understand you brought with you some testimony from the FTC Chair Lina Khan in a recent oversight hearing. Would this be a good time to play that so you can talk about that a little bit?
Yeah, I think it would be interesting for our listeners to hear what Chair Khan said when asked specifically about ESG in a Senate oversight hearing.
Ms. Khan, do you agree that collusion to restrict supply is generally unlawful?
As a general matter, collusion is unlawful.
There's no antitrust exemption because you call something ESG, is there?
No, to the contrary, we've seen firms come to us and try to claim an ESG exemption, and we've had to explain to them clearly that there is no such thing.
So I think that's Senator Tom Cotton interviewing her. Is that right, David?
That's right.
And can you elaborate on what all this means? Why does she say this? And what's the context in which the Republican senator from Arkansas was questioning her about it?
The reason that Chair Khan says there isn't an ESG exemption to antitrust is quite simply because it's true, and there isn't such an exemption. And as I mentioned, Section 1 of the Sherman Act prohibits agreements that unreasonably restrain trade. And under U.S. antitrust law, there is no good intention exception to the antitrust laws. You can't fix prices, reduce output, allocate markets, or otherwise agree to take anti-competitive acts, even if your intentions are worthy. And that's, of course, not to discount the importance of environmental sustainability or pressing social issues, but the doctrinal answer is that under U.S. law, to the degree coordination harms competition, then it's illegal.
So I want to ask yet another question around, in particular, Section 7 of the Clayton Act, which would prohibit any merger or acquisition, the effect of which would be to substantially lessen competition. Now, typically you would have, even once you showed substantial lessening of competition, you have the ability to rebut that presumption by demonstrating efficiencies. I think there's an open question, or I would be interested in your views as to whether ESG factors should be considered a relevant efficiency. Let's say companies say, as a result of our merger, we will emit less, carbon emissions. Should that be relevant? Is that relevant? How could the agencies consider that in their analysis?
Chair Khan says we have people coming to us and saying, we'll make these ESG commitments, we'll accomplish these sort of ESG favorable outcomes if you let this merger go through. And Chair Khan takes a very strong line that does not allow an otherwise illegal merger to go through. And of course, whether we're talking about Section 7 or Section 1, when we're talking about something that we might, I know it's not technically rule of reason in a Section 7 context, but when we're talking about that sort of analysis, it's very clear that you're taking in all sorts of factors that go to competition, but you're not looking at non-competition factors. And so, outside of the United States, and you could certainly imagine a change in law that would change this, there are ways to take sort of balance the trade-off of something that might be more environmentally friendly, even if it harms competition. But under U.S. antitrust law, that's not an excuse. That's not an exemption. There's really no way past that.
Well, all this sounds pretty theoretical, but let's try to put some flesh on the bones. Derek, are there existing empirical examples that you can think of that are in the case law now where this has become an issue, i.e. there's a good motive, but it ran afoul of the antitrust laws?
Yes, Melissa. So one case where this issue has come up is actually in the processed egg products antitrust litigation. So in that case, you had United Egg Producers, which is a cooperative of egg farmers and sort of an association representing the interests of the egg farmers. They created a certification program whereby if their members agreed to certain standards limiting the number of hens they could have per cage, then they could market their eggs as certified by the United Egg Producers. So you have sort of the tension that David and Chair Khan were talking about. You have this pro-social goal of promoting animal welfare and healthier chickens, and counteracted against this potential restriction on supply. And so there was a class action suit brought on behalf of purchasers of eggs who argued that this was an illegal restraint on supply under the Sherman Act. And on the other side of that, you had the egg producers arguing this is not a naked restraint on supply that should receive per se treatment. Instead, it should be judged under the rule of reason. And their basic argument was, one, this doesn't actually impact the overall supply of eggs. Farmers can always build more cages, even if they're only permitted to have fewer chickens per cage. And in fact, there are a bunch of other benefits from having fewer chickens per cage. You have less disease, you have healthier, less stressed chickens, and you might see higher rates of egg production as a result. At the end of the day, the egg producers' argument won the day. The Eastern District of Pennsylvania District Court judge agreed with them that the rule of reason should apply. It actually went to trial, which is unusual for an antitrust class action, and they won a favorable verdict from the jury, which was upheld on appeal by the Third Circuit. So I think this case really illustrates the tension that David talked about between certain ESG pro-social standards and potential conflicts with supply, but also that not every ESG initiative will amount to a anti-competitive restraint of trade, and companies and trade associations thinking about these initiatives would do well to consult with antitrust counsel and think through, potential arguments about why these may actually be pro-competitive.
So it sounds like to me, and I'm going to ask this question to David, when you're balancing a rule of reason case, you're taking into the pro-competitor factors, not only pro-competitive from an economic point of view, but also pro-public policy. Is that what I'm hearing?
So I don't think that's quite right, Melissa. I think the rule of reason really is looking at competition, and it's sort of weighing the scales, but it's weighing the anti-competitive effect versus the pro-competitive effect of a given agreement. And I think it's important, right, that the judge didn't say that the jury maybe didn't say that the agreement on eggs was okay because going to assign so many units of utilization to kind of chicken happiness versus and weighing that against the overall price of eggs. It really was an analysis that was focused on what was the actual competitive effect of that agreement, and if in that case, if the defendant had conceded, well, yeah, this will raise the price of eggs, we've agreed all to raise the price of eggs, but really, as a society, we should value animal welfare so much that we should all be willing to pay an extra 10% for eggs. That would have almost certainly lost, at least under doctrinal approach to antitrust law. Now, that's not to say, and we'll get into this, that's not to say that those judgments couldn't be made, but those judgments aren't going to be made by competitors in a marketplace. They're going to be made by political actors, whether that's Congress or state legislatures or the appropriate regulator.
So if there's no ESG exemption, qua ESG exemption, what does that mean as a practical matter for companies who are trying to infiltrate ESG-related topics and benefits, social benefits, into their business plan? What are they left to do?
Yeah, so there is ample room under U.S. law for competitors to engage in pro-competitive, or at least not anti-competitive collaborations. And as we've already alluded to, outside a narrow set of naked restraints on trade, like price fixing, agreements in the United States are analyzed under the rule of reason, which looks at whether an agreement imposes an unreasonable restraint on competition, taking into account a variety of factors, including specific information about the relevant business, its conditions before and after the restraint was imposed, the restraint's history, nature, and effect. And so, the bottom line is, as long as the pro-competitive benefits of the agreement outweigh the anti-competitive benefits of the agreement, then the agreement is legal. And so there are plenty. I mean, every day, competitors are getting together and they're making agreements that are completely above board and consistent with the antitrust laws. There is a whole host of guidance. Certainly, I'm sure everyone on this podcast would be happy to help counsel a client about a specific agreement and how to structure that in a way that is not violative of the antitrust laws. The federal antitrust agencies also have competitor guidelines where they have state here are the kinds of agreements, here are safe harbors for agreements that you can make that we're not going to enforce against, because we view them as pro-competitive. And there's also standard setting, which happens all the time, and that doesn't mean that that it can't violate the antitrust laws. But there's lots of really strong examples of companies and whole industries really having agreements that don't violate the antitrust laws and that can advance something pro-competitive, including something pro-competitive that relates to ESG.
Well, let's turn to those standard setting agreements. And are there any potential exemptions that might cover ESG related activities? I know we mentioned Noerr-Pennington at the beginning of the podcast. You do want to comment on that, or the state action doctrine? I know also there's a National Cooperative Research and Production Act of 1993, which allows you to get a limitation from the Justice Department to do something that's good for the world. Can you talk about those, about what either statutory or case law, judiciary exemptions or help might be there for a company struggling to do the right thing and not wanting to get into antitrust trouble?
Sure. And Melissa, you're showing off your vast knowledge of antitrust immunities and exemptions that you've learned by being co-chair of that committee for the ABA. So So there are exemptions out there, and many of which could certainly come into play related to ESG. And I think probably the most prominent one is Noerr-Pennington. And Noerr-Pennington shields an antitrust defendant from liability for competitive injuries that result from concerted or individual petitioning that's reasonably calculated to change sort of a government policy or rule. And so what that means is, I mean, let's just kind of take a hypothetical. So you've got a widget maker that has a process that's maybe not particularly environmentally sound or friendly and wants to move that to a different process that is better for the environment, but it's more costly. And of course, that widget maker faces a problem because if that person does it on its own, it's going to be at a disadvantageous competitive cost structure. And so that widget maker could do it on his own, no antitrust issues. What that widget maker should not do is call up all of his competitors and say, let's all agree to move to this new process together so that we all have the same new cost structure and none of us is at a competitive disadvantage. That would be an antitrust violation, almost certainly. But under Noerr-Pennington, that widget maker could on its own or in coordination with every other widget maker lobby Congress or a state legislature to say, why don't you change the law and outlaw that old process, or maybe do something that puts a regulatory burden on it that encourages people to switch to the new process. And again, that could have, at least in the short term, an anti-competitive effect because the price of widgets might go up, but there won't be any antitrust liability coming from that. And it really goes back to, and this is also the same idea underlying the state action doctrine, which is that the antitrust laws don't apply to governments. The antitrust laws apply to private actors in the marketplace, and they don't apply to government actors. And the government can decide to do something that from a narrow antitrust perspective might be anti-competitive, but that advances an overall public policy that's beneficial, that's pro-social. And that's really where Noerr-Pennington comes in one way that an exemption could be applicable in ESG without being an ESG exemption, but still an exemption that could be available for someone trying to do something related to ESG.
That's great. I just one last question. How are other jurisdictions handling this issue, like the European Union countries?
Yeah, so it's an interesting question because I think we're poised to see some divergence. There are draft guidelines in the EC on sustainability collaborations that would create safe harbors for certain sort of sustainability standardization agreements that meet certain criteria. One of the criteria is they couldn't result in a significant price increase, but that means they could result in a price increase. I think there are outside of the United States, especially in Europe, although there was just an article the other day about the JFTC also considering guidance and changing the standards on these rules. There is a movement to see the law change to allow for collaborations that might even be anti-competitive in a strict sense, but that nevertheless are pro-social in some way. But just to be clear, that's not the law in the United States. At least not right.
The irony, of course, right, is that in some ways you need the regulators to all agree that this is okay in order for companies to actually implement it, at least cross-border companies to implement some of these collaboration agreements.
Absolutely. And as I think we've probably all experienced in counseling and representing clients, when there is divergence between significant jurisdictions, it creates a significant
race to the bottom or race to the top, however you think of it.
Right, exactly.
Well, I mean, this all kind of circles back to what we started with, which was episode 16, which had basically a conflict between the federal government approach to air emissions and the state of California approach. If we're going to be getting into this with international companies who have to abide by EU regulations in certain areas anyway, how they're going to adapt in the United States is going to be a challenge.
Well, David and Derek, this has been very interesting. A lot to watch, I think, as the ESG movement continues to gain some momentum. But before we let you go, we do like to ask you guys some more personal questions so we can get to know you. So I guess, Derek, I'm going to start with you. Tell us something about yourself that those who work with you wouldn't know.
Well, one thing that I think even my colleagues here may not know is that I once played the song Go Tell It on the Mountain on an alpine horn in the middle of BWI Airport.
Amazing. An alpine horn. That is, that's like the big, right?
Yeah, it's like the big
size
Ricola commercial
right.
tree trunk instrument. So
I'm impressed that you can play that, let alone that you publicly played that instrument.
There are not a lot of songs you can play on it. But
what gave rise to this?
So I played French horn growing up, and my French horn teacher had traveled to Switzerland for an international horn society workshop, and he brought back with him this very expensive and complicated to ship authentic Swiss alpine horn. And so he started a practice. We used to play a holiday concert every year in BWI, and high school seniors who were graduating would get the chance to play the alpine horn at this holiday concert.
Okay. And David, how about for you, advice that you have for young lawyers who are looking to do what you do?
No, I want to hear him beat that one.
I'll get him on the curious hat. Don't worry.
Okay.
Sure. So, advice for lawyers who want to do what I do. I had the enormous privilege and opportunity to work at the Department of Justice Antitrust Division, and there really is no better place to learn how to be an antitrust lawyer than working at one of the federal antitrust agencies. You're just with so many smart people who are singularly focused on that. And it's just an amazing environment to learn and understand. And I think now that I'm back in private practice, it's just very helpful just to understand when you're talking to one of the enforcers what's going on in the background and sort of giving advice and navigating that. So I would recommend, if you have the opportunity to work at DOJ Antitrust or I think the FTC, then you should take advantage of that.
Great. And now for our final segment, the Curious Hat.
And now it's time for the Curious Hat.
So David, I'm going to start with you. Historically, we would ask you to pick a number, but we figured that doesn't actually work out because people who listen to our Curious Amalgam will know what number to pick. So I'm just going to pick one out randomly. David, if you could choose free front row tickets for any performing arts show or festival in the world, what would you choose?
Oh, wow. This is a tough one. I think there is a an amazing classical music sort of festival that happens in Salzburg every year, and I think I'd go there, and I'd bring 3 tickets. So I take my wife and someone else. I've got 3 kids, so
free ticket. You can take your entire family. This is free ticket.
Okay, good. This is a double.
You're gonna have to pick among one of your kids.
Yeah, right. Well, I was about to tell you which was my favorite, but I'll thank you for saving that, Christina.
Great. And Derek, I guess speaking of chickens, or not so much chickens, but potential pets, are you a cat person, a dog person, or neither, and why?
I am both. I grew up as a dog person, and I still love dogs, but my wife is a big cat person, and so now we have 2 cats, and I absolutely love them. I always sort of thought dogs are, really friendly and get up in your face, and cats are a little more standoffish, but it turns out cats can actually be quite friendly too, and our cats are great. So.
I've been on Zoom calls with Derek, and I have seen cats jump in.
Yes.
So you've
seen the friendly cats live, yeah.
Yeah, they love to get right up in the camera whenever I'm on Zoom. They're fascinated by it.
Well, Derek and David, thank you again for joining us today. And for all of our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.